I'm going to discuss in this video the Republican talking point that the Republican justices only apply the Constitution as written, rather than making stuff up to fit their religious and ideological beliefs on major hot-button issues. I'm going to discuss in this video two such issues, abortion and guns. The purpose is not to take sides on those issues in this video, but simply to point out the hypocrisy of the Republican justices. They do just make stuff up. The Dobbs decision, which reversed Roe v. Wade, was written by Justice Alito and was released on the same day as the Bruen, B-R-U-E-N, decision, which invalidated a New York gun law. To invalidate a state gun law, the Republican justices had to incorporate the Second Amendment into the Due Process Clause of the 14th Amendment, which is a judge-created constitutional provision of recent origin, meaning, in this case, 2010, which was the first time that the Republican justices were able to discover the Second Amendment lurking and hidden in the Due Process Clause of the 14th Amendment, which was passed in 1868. The first Chief Justice, and this is their problem, John Marshall, who was a contemporary of the founders, stated in the Barron's decision that the Bill of Rights, which would include the First, Second, Fourth, Fifth, and Sixth Amendments, only applied to the federal government. Actions by state and city governments were to be judged under state constitutions, according to Marshall. Now, are the Republican justices going to say that Justice Marshall did not know what he was talking about? He's the most important jurist in American history. And he was a contemporary of the founders. And are they going to say that he didn't know what he was talking about when he made that decision? The essence of what Marshall was saying was that he knew the intent of the founders, and the intent was that the Supreme Court had no authority to overrule actions by the state under the U.S. Constitution. So that's just a huge problem for the Republican justices who claim to be originalist or strict constructionist. Anyone can read, it's a really short decision. The Barron v. Mayor Baltimore, 32 U.S., page 243, at pages 250, 251. It's a Justice Marshall opinion. To apply the Second Amendment to the states, those Republican justices had to find some other provision in the Constitution, given what Justice Marshall said about the Second Amendment not being applicable to the states. And that provision was the Due Process Clause in the 14th Amendment. And that was adopted in, as I said, 1868. To incorporate the Second Amendment into that clause is a judge-made constitutional provision. It's just totally made up. Arguments can be made that incorporating the Bill of Rights into the Due Process Clause, which would then make those constitutional rights applicable to state actions, is a good policy. That is not the issue when a Republican justice who claims to be an originalist are interpreting the Constitution as written. If they were consistent, then the Second Amendment would only apply to federal laws, not state laws. The first time the Supreme Court applied the Second Amendment to invalidate a state gun law was in McDonald v. Chicago, 561 U.S. 742, a decision from 2010. And this is when they found the Second Amendment in the Due Process Clause of the 14th Amendment. Alito wrote that decision, and he incorporated the Second Amendment into the Due Process Clause of the 14th Amendment in order to strike down a city gun law. He had to do that to invalidate the law. Alito also wrote the Dobbs decision that reversed Roe v. Wade. The Due Process Clause of the 14th Amendment has truly become magical. It simply states that no state shall deprive a person of life, liberty, or property without due process. No language of incorporation is present in that clause. The lawyers in Congress then knew how to incorporate by reference. It would be so easy to do. Just say the First, Second, Fourth, Fifth, and Sixth Amendments are incorporated by reference and applied to the states. They did not do that. The drafters of the 14th Amendment were also well aware of the Supreme Court precedent that I earlier discussed from Justice Marshall, that the Bill of Rights only applied to the federal government, to restrain the federal government. And they could have made their intention extremely clear, knowing that precedent, in order to change it when they drafted the 14th Amendment, but they did not do that. Due process is understood as strictly procedural by lawyers in that a person is entitled to a hearing and a trial by jury. It does not incorporate anything by its express terms. It was not until 1925 that the Supreme Court first found a constitutional right enumerated in the Bill of Rights, lurking and hidden in the Due Process Clause. Previously, no one knew that such an incorporation was even present until that first decision in 1925. This was when free speech was incorporated and applied to state action. That's a good policy, but that's not the issue when the judicial interpretation standard is to apply the words as written and as commonly understood when the provision was adopted. And as I said, Justice Marshall already stated what the Bill of Rights meant as far as state action. It had no application to state action. The constitutional foundation of Roe v. Wade is the right of privacy to be free from governmental interference in decision-making when it comes to private matters. That right is not specifically expressed in the Constitution either. The incorporation is not expressed either. There's only a right to be free from unconstitutional searches and seizures in the Fourth Amendment. But creating the right of privacy out of the Due Process Clause and incorporating the Second Amendment into the Due Process Clause are both judge-made rules, where the Republicans favor the Second Amendment incorporation, but disfavor the right of privacy, which, after all, it is a conservative value to be free from governmental interference in private matters. What has happened, in effect, is that the Republican justices that we have now have arrived at a constitutional interpretation that reverses Roe v. Wade and the right to privacy, but also prevents states from passing reasonable gun laws to deal with the escalating violence in the United States. The interpretation is hypocritical, in my opinion, and it is consistent with a 19th century worldview and the religious beliefs of the Republican justices. And that's it. 5 of the Republican justices are Catholics, and the other one, Neil Gorsuch, was raised as a Catholic before becoming an Episcopalian.